Welcome to Ground Rules, employment law over your coffee break. My name's Pam Howland, and I'm here today with Jennifer Walrath and Doug Plass, two attorneys in our office. And we're here today talking about things to consider if an employee gets arrested. So we get a number of calls about this, and it seems like in recent times we've received more these type of calls more often. And frequently, they're somewhat emotionally charged, right? The employee learns that, or the employer learns that an employee's been arrested for assault or battery or DUI or domestic violence. I mean, you can really fill in the blank here. And as you can imagine, it creates a level of fear and uncertainty for the employer. You know, what do we need to do about this? Is our workplace in danger? Should their coworkers be concerned? What can we do? What can't we do when it comes to when an employee gets arrested when they're working for you? So as it turns out, there are a number of considerations to talk about here, maybe not too surprising, and we want to walk through some of those with you. Some you might be surprised by, some maybe not, but it's an interesting issue and one that we thought you might like to get a little bit of input on. I can think of a couple of cases where I've had situations arise. This might be the worst one I had. It was a number of years ago, probably 10 years now, where an employer learned that an employee had been arrested as a sex offender for molesting kids, and as it turned out, that employee worked in a warehouse setting by themselves, away from contact of other employees, but other employees in the workplace had learned about it. They were up in arms and they were demanding the termination of this employee. And the employer was completely, worried about what to do. What can we do? What can't we do? Our gut instinct is we need to get this employee out of here. But what are the guardrails here? What are the parameters we should be thinking about? So we're going to talk through a few of those. So Doug, maybe kick us off here and help us understand some of the basic considerations that we need to be thinking about if you have an employee who gets arrested.
Thanks, Pam. Yeah, so I think the first thing to do is just pause and recognize that an arrest is not a conviction. An arrest is a police officer thinks a crime has been committed. That's it. We don't have nobody's been in front of a judge yet. We haven't proven anything. So a lot of times people get arrested on one charge, and then by the time either the charges are dismissed, or by the time they get in front of a court, a prosecutor will make a determination that the charges are actually something different and often something lesser. So employer needs to be careful about taking action on it, about arrests that might not necessarily turn into a conviction. But on the other hand, kind of the burden of proof from an employer's perspective is not the same thing as a court's perspective. So the employer needs to kind of think about, do a little bit of investigation, ask the employee what happened, try to figure out what the basis is it for before you get to this point where you're going to go ahead and make a termination and kind of believe everything that has been charged against that employee. So, give your employee a chance to kind of explain it to you and give you the same evidence that they'll end up giving to the court later for your determination.
Yeah, and I've seen kind of along those lines, I've seen employers who do in-house background checks. So maybe they're searching different databases, and I've seen where both pop up, both arrests and convictions. And that can be, I think, very confusing for employers. Like, what do I do about the arrest? So I think that's a really key concept here, is be very careful about acting on an arrest. We're not criminal lawyers here, but we do know enough to know that there's all these concepts of fairness and due process. And it's very dangerous to make decisions based on only an arrest. Jennifer, what do you think about that?
Yeah, no, and I was going to piggyback on what Doug was saying, and I think is a kind of a common thread in a lot of the topics that we discuss here, is finding a way to gather information in a defensible manner. So if you need to make a decision to act in a particular way, you have a good basis to do so. Doug and Pam both mentioned, potentially just asking the employee questions to get their take on it. But another thing you can do is to actually hire an outside investigator and do an investigation. And we have had some clients do this. And for example, sometimes whatever the alleged conduct is, it may, for the employer, not even be all that relevant whether or not it's a crime. It might be something that violates their policies, or where if it is something that the employer hires someone to say, I think it probably happened, you might decide you need to take some kind of action. It's not termination, to do something. But if you decide to do something or not do something, it is based on, kind of a fulsome investigation by a independent third party is always kind of the best way to do that. While that's happening, depending on what it is, you may have to also be considering whether to put the employee on some kind of leave, have them out of the workplace. For some things, that may not be necessary. But for example, like the example Pam gave, if you have people in the workplace concerned about safety, for example, that might be one where even though the claim is not yet, validated either way, you can put the employee on leave. In that situation, we would recommend paid leave for the employee. Generally speaking, whenever you give someone paid leave, it is highly unlikely that it would be considered an adverse action against the employee. And the reason why you would do that is consider a scenario where, an employee, like the example Pam gave, accused of sexually molesting children. If you put the employee on unpaid leave, but look into it and then find out that there's nothing to it, at least from the employer's perspective, and bring the employee back, that employee can say, well, you actually already took unlawful action against me, and potentially that could be a basis for some kind of a lawsuit. So paid leave is always going to be a safer way to approach it. Having someone come in, do some looking into it to the extent that the underlying conduct relates to the person's job or your policies, and then you can take action appropriately from there. And generally speaking, do it relatively quickly too, especially if it's a more serious accusation.
Yeah. Unpaid leave. We have a few lawsuits where the only adverse action that the employer was accused of, and remember, in any discrimination case, there's got to be typically some type of adverse action as an element that the employee plaintiff has to satisfy. Putting someone on unpaid leave can in some cases be the final step that makes a claim ready to go forward. So be very careful about putting people on unpaid leave pending investigation.
And one thing I forgot to mention real quick about, kind of the value of doing an investigation as an employer, as Doug mentioned, there is a difference between, an arrest and a conviction, and the process that runs through the courts to figure out what ultimately will happen with any criminal claim can take a while. And as an employer, you probably, in most cases, don't have the luxury of waiting until that final outcome exists until you can decide what to do with this employee. So really, the investigation would give you the tools you would need to make a decision from an employment law perspective, what makes sense and what you can do, shouldn't do, et cetera, with that employee.
And one thing that came to mind while Jennifer was talking about investigations is, so in Pam's example, the employees are the ones that were talking about this, and I'm sure there was lots of chatter in the workplace. That won't always be the case, but the idea of trying to keep this a little bit under wraps is a good one, right? Like especially if it turns out there's a wrongful arrest, wrongful conviction kind of situation where you've been kind of everyone's been discussing this employee and all the bad things that they've done in the workplace. I mean, that could be an adverse action potentially as well, or at least retaliatory in some way. So.
Yep. So one thing I ran across as we were getting ready for today, which was not really on my radar, but for all of you employers out there who have offices in other states, there are actually a number of states that statutorily have made it illegal for employers to consider arrests in the hiring and firing process. Again, we're in Idaho, not a lot of law here on employee favorable things like that. But that is something to be aware of. The probably not too surprising, the state that jumped out, California, of course. But I also saw Washington State has a law that says you can only consider arrests going back a certain number of years. So that is something to be thinking about too. And this arrest consideration can be a big deal in the hiring process too. We're not just talking discipline of a current employee, but this situation can come up in the hiring process too. So let's talk a little bit about other considerations like EEOC guidance out there that kind of sets some parameters on when you can consider arrests in the hiring process.
Yeah, and I have some few thoughts on that. I mean, okay, so the EEOC, as I think we've talked about before, is concerned with enforcing laws prohibiting discrimination against persons based on a protected class status. One thing is that there are potentially persons in certain protected classes where statistics show they might be more likely to be subject to, unlawful arrests, for example, right? Which would make it more risky to consider arrests because the person who doesn't get hired, for example, might argue, well, the real reason that you didn't hire me is not just my arrest, but it actually is related to my race or my color or my ethnic origin, right? National origin. The other thing, too, is that if considering an arrest is not really necessary for the job in question, that just lends to questions as to the legitimacy of that being the reason why you didn't hire a particular employee or why you chose to fire a particular employee, which, as we always say here, whenever you open the door to a question mark as to whether or not the reason why you're doing what you're doing is a legitimate, non-discriminatory reason, there is potentially an avenue where someone could say the real reason that you did it or didn't do that was unlawful. So that's a long way of saying when you are looking at things like arrests or convictions, there is the potential that if you make a decision based on that ground, it could lead to a claim of discrimination that would be unlawful. And the EEOC has talked about this. And what it really comes down to is the nature of the job and the nature of the crime. For example, if you are maybe like an accountant and you get arrested for a financial crime, there's a lot of a link, right, between the financial crime like theft or fraud even, and the job that you do. So a conviction on that basis may well be a legitimate reason why you would choose to either terminate someone if that occurred while they were in your employ, or if it was something that was a prior conviction that comes up during a background check when you're getting ready to hire a position. If you have an employee where driving is required and having a legitimate driver's license and they get a DUI, that is something that might be validly considered. But if they're in a position where driving is not required, then it may not be something that has a sufficient tie to the job duties and the job requirements. So those are some things to consider. Overall, the EEOC says, look at the nature of the job. What are the duties? Does the crime, and I think in this case, the conviction actually relate to those duties? And then also thinking too about how old is the conviction or the arrest that you're looking at. Something that's 10 years old, 15 years old. I mean, is it really going to be something that has any bearing, right, on the job and what the person is trying to do now? And then I think too, when it comes to any crime that has sort of a safety component, like maybe an assault or a battery, if the person has a lot of interaction with the public, for example, that might be something where it is legitimately considered But again, just whenever you're thinking through that process, take a minute just to think about, is this a legitimate reason why we would either terminate or not hire this person? And is there any risk that if they were to, try to file a lawsuit later, they could argue that it was actually us discriminating against that individual based on some protected class status?
Yeah, and while you were talking, I started thinking, what would a DUI be disqualifying for? And it might be more than just driving, if you're hiring a risk manager, for instance, or something like that. So, really think it through, I think. But also, to add on to what Jennifer was saying, well, in some way, right? In some way, or if you have, some sort of public facing role where where your employee is putting themselves out as some sort of model to the community, that certainly would be somewhere you might want to consider. So the EEOC also says that we need to treat our applicants all the same with regard to how arrests or convictions are considered, and not just applicants, our current employees as well. And so, for instance, if you have two applicants and they both have a prior arrest, you want to think about them the same. You want to make sure that they're being viewed in a similar way, and you're not treating some applicants differently because of arrest history. And this is particularly in light of what Jennifer was talking about certain communities maybe having higher incidences of arrests. If some protected classes are more likely to have arrests or convictions, you need to be really careful about unfair treatment directed to those classes. So, for instance, if you have a white applicant with a criminal record, you need to consider it the same way that you would treat a black candidate with a criminal record. So really just have good policies and be even-handed about it, which goes back to what we always talk about here on the podcast.
Yeah. So that was going to be my final punch here, is talking about policies, handbooks, the importance those play. I can think of a handful of policies that relate to this. And as we created our handbook, we've tried to take away from different cases that have come up and different situations where our clients have found themselves, and have tried to incorporate into that handbook policies that might come in handy if you have a situation like this. So one would be the background check policy. And, this might be a reason why you want to do a background check. Sometimes employers are like, I don't know, do we really need to do that? Well, better to find out on the front end than to hire someone and find out they have some kind of arrest, conviction, something that takes you by surprise, that can be shocking and result in a lot of uncertainty and fear for employers. So a background check policy that basically says, maybe how are you going to treat arrests and convictions? What are the type of factors you're going to consider if there is a hit on a background check? So that's a good one. Another one that I've added over time because of the very situation we're talking about is a mandatory disclosure of arrests and convictions policy. So this goes to your current employees. Say you have a 20-year employee. What you don't want is one day you come into the office and someone shares with you that a longtime employee has an arrest or a conviction that they got at some point while they were working for you, and you didn't know about it. So something requiring disclosure of arrests and convictions. Obviously, you're going to have language in there that, exempts basic driving citations, minor ones. But for big things, better to have a mandatory disclosure so you know about it. A workplace safety type policy, safe workplace, workplace violence free policy. That can be important here, where we were talking about situations where maybe you have an employee who gets an assault or a battery conviction. if you've got a policy that says we have a safe workplace policy here, that might give you a little more leeway in asking a few more questions about this, looking into it, and really diving into whether or not the facts create a problem for that employment. Let's see. How about this last one? So going back to that example that I kicked off with, where the sex offender employee was arrested for being a sex offender. In that case, the employer decided to go back and look into their code of conduct policy because they didn't really have a clear-cut avenue for addressing this, and they ended up adding a code of conduct policy provision that said, it's prohibited to engage in conduct that's disruptive or interferes with coworkers' ability to work. I know that seems like a bit of a stretch down the road, but that really was what happened when all the coworkers found out about this. It was just chaos in the workplace. Like, I don't feel comfortable. I don't want them here. A good code of conduct policy saying what type of things are prohibited can be very useful with performance management, discipline, all that good stuff. Kind of the situation Doug was talking about. If you have an employee who's charged with being a role model, setting a good standard, I mean, something that is, what's the word that we see in our world, like a kind of like, something that questions their ethics and integrity, that could be something handy. And obviously a public arrest on something that's very distasteful or something, who knows what that could be. But anyway, check out your code of conduct policy. And as we counsel our employers, think through the type of situations you've had over the past couple of years. Has anything happened where you needed a policy and didn't have one? And if that's the case, time to go in and update your policy. So not only are you looking for changes of law, but situations that come up that create challenges, those might be good things to update the handbook on. So with all that in mind, a couple of little plugs for Idaho employment lawyers. We do have a workplace investigation training coming up on September 25th, I believe. So if you're listening to this thinking, if we had somebody who had a situation come up in the workplace and we would have no idea how to investigate that, as Jennifer said, getting a third party, neutral, qualified investigator, that's always preferred. But there may be situations where you want to internally investigate something, and that's what our training in September is aimed at helping you do, is know the basics of a solid workplace investigation that would hold up, where you could defend yourself if there was a question about what you did was legal. So check that out. Check out our Law for Leaders book. Check out our Law for Leaders training content. Again, we have recorded content, we have live content, we can do custom content and everything in between. And that's it for today on Ground Rules. We'll see you next time.
Ground Rules hosts and guests are not providing legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction.